Welcome to the Napa Legal Podcast. I'm Frank Devito, Senior Counsel and Director of Content at Napa Legal.
I'm Mary Margaret Bush, Napa Legal's Executive Director. You're listening to the Napa Legal Weekly Podcast, where we explore religious liberty from the perspective of faith based nonprofits. This week, we'll recap oral arguments in the St. Isidore versus Drummond case. We'll talk about an Indiana parental rights bill protecting the rights of parents of all faith backgrounds, and we'll conclude with a free speech victory at a university.
All right. And with a lot to talk about, I guess we will jump right in. So, the St. Isidore case, as it's commonly called, this is the Oklahoma Virtual Charter School lawsuit with the Attorney General of Oklahoma, Drummond. So, it feels silly to recap this case because I know we've discussed it, I think, at least twice on this podcast, but I want to at least assume a little bit that people might be listening for the first time. So, very briefly, the background, this is the case where a charter school, virtual charter school, was set up in Oklahoma. So they applied for charter school status despite being an explicitly Catholic school. That violated the apparently the statute in Oklahoma for charter schools, which bars sectarian institutions. And then the Attorney General of Oklahoma stepped in and filed a lawsuit claiming that it also violated the Establishment Clause of the U.S. Constitution as well as the state constitution in Oklahoma. So that's where we are. It very quickly became a legal battle that went up to the Oklahoma Supreme Court and now to the U.S. Supreme Court. Oral arguments just happened. By the time you're listening, it will be last week. And what I want to do here is just kind of focus briefly on each of the three main questions that are at issue in this case, and then maybe reflect a little bit about how I think this will go down. And Mary Margaret, I think as I get through each question, I'll maybe kind of turn to you and see if you have thoughts. I think they're all very different questions. So just to kind of roadmap where we're going here, the first question is whether the Catholic Virtual School is a state actor because it receives government funds and signs this contract to become, a government affiliated charter school. So that's the first question. The second one is whether government funding of a religious charter school violates the Establishment Clause. And the third question is whether excluding St. Isidore from the charter school program solely because of its religious character violates the Free Exercise Clause. So numbers 2 and 3 are kind of familiar to religious liberty Supreme Court watchers. We've been discussing these questions from Trinity Lutheran on, especially in Carson v. Makin, which was now 3 years ago already, right? 2022. So those are a little more familiar, but I want to touch first on the less constitutional question, but I think it's a really important threshold question, or at least it could be, whether the St. Isidore School is a state actor. So just on the facts, the school argues that no, it's not. And I think that on its face is a pretty convincing argument. I'll be interested to hear your thoughts, Mary Margaret, on this in a moment. But so the school notes that in the arguments that it was privately created, right, which is a big step in not being a state actor. It was not created by a government action. It was created how every normal nonprofit organization is created, right? They get a board, they incorporate, they do their whole private thing. And so it's not a creation of the government. That's the first note, privately created. They also argue the state doesn't run the school, which is also self-evident, and that there's no overlap between government and school personnel, right? The school chooses its own teachers, its own board members, and so on. And that the government funding in general historically has not constituted making a private entity magically a state actor. I think they're good arguments. But the answer to the question matters, which is why the court focuses on it. It's why this question is up for debate in the first place. So why this is not just an argument about Establishment Clause and Free Exercise Clause. So I want to back up a little bit and say, as we'll explain when we get to the Establishment Clause claim, I don't think this shouldn't be the main issue, right? There shouldn't be an Establishment Clause issue. Anytime the government is funding or favoring religious institutions, as long as it isn't favoring one denomination and excluding others. I know I've beaten this drum a lot of times on this podcast, but I think I should keep doing it. Right. So I don't want to say it doesn't matter whether the school is a state actor, because it does. That's an important legal question. But for questions of whether this is an establishment of religion, I don't think it's really the most important question, because it's not about whether the school is a state actor. It matters whether the state, by supporting this school, is establishing a religion. And as I've said time and again, it's not, unless Oklahoma's charter school board turns around and starts denying every Protestant or Jewish charter school application and says, no, we're only, either by word or by fact, we're only establishing Catholic virtual charter schools. Then you have an Establishment Clause problem, right? But just plain meaning, original meaning of the Establishment Clause, the way I see it, this is not properly an Establishment Clause question, regardless of how the state actor question is decided. But the way the law stands now, this is generally an important question to get to, right? It's a bold proclamation that a charter school becomes a public actor by entering into this contract with the government. It's a lot like analogizing to the Baltimore Lutheran case and the Hillsdale case that we've covered previously. If the government stretches so far as to say that by having 501c3 status, you're now receiving a government benefit, that leads to such a cascade of legal issues and entanglements that we don't want to go there. And it's a novel claim. I think it's a similar thing here. By virtue of signing a contract with the government and receiving funds from the government, if that makes you a state actor, I think there's a huge cascading effect because there are plenty of institutions, organizations, individuals who have contracts with the government to do certain things. And they would, if they become state actors, I think there's a huge slippery slope. I think you quickly open the door for a lot of messy legal problems. Um, on the other hand, a bold proclamation here from the court that charter schools are not are private actors, that they are per se not state actors by virtue of signing a charter school agreement, that could have a really big effect too, right? If the Supreme Court goes big here and says no, charter school contracts are not turning private schools into state actors, period, then and if we get the ruling that we want otherwise on this issue, this would quickly open the door for other states to start chartering religious schools, right? Because then there's no more state actor question, and that I think changes the game. But I will say, and we'll talk about this at the end when we talk a little bit of court watching and speculation here. I think there's a pretty good chance that in this ruling, the court might go a little more narrow than big time St. Isidore religious liberty fans are going to want. And I'll get into that in a few minutes, but it's partially the makeup of the court and the fact that Justice Barrett has recused herself, I think may very well change the nature of this ruling. That's just a guess. Not speaking on behalf of Napa Legal. I have no insider knowledge here, but the reality is to get to 5 votes now, you need Chief Justice Roberts. Chief Justice Roberts tends to like narrow opinions on hot button issues. So I think there's a good chance, especially on the state actor question, that the court maybe rules on the facts here and says that in this instance, the way that the Oklahoma charter school contract is put together, St. Isidore is not a state actor, but then leaves the door open to say that other charter school contracts or systems may go further and indeed leave that state actor question open for another state and another day. I don't know. I have no inside information, like I said, but I would just kind of preface all of our discussions on St. Isidore with my concern slash minor prediction that the absence of Justice Barrett on this issue may make for a more narrow ruling. So before we dive into First Amendment questions, Mary Margaret, do you have anything on the state actor issue or anything else I just said?
I think just bottom line with that state actor issue is that opponents of religious freedom, they want an expansive state actor doctrine because it expands control. Typically, the opponents of religious freedom are big government people. They want the government at the helm, and I think that's what's driving this advocacy for an expansive view of who is a state actor. And I think we'll have the chance to allude to this a little bit more at the end, but I think particularly Kennedy versus Bremerton School District, but a number of recent cases clarify that um, when a religious organization or when a person of faith collaborates with the government in some way, um, that does not automatically make them a state actor. And it does not automatically give the government or anyone else the right to muzzle that person or that entity or condition their participation in a publicly available program on the renunciation of their faith or their beliefs or yeah their identity. And so I think the push for the expansive state actor doctrine is kind of, I think that's where this is coming from because it comes across as technical, but I think that's kind of the policy driver behind this back and forth, which in a way almost seems like a technical sidebar to the issue of the real First Amendment issues here. So yeah, I think you recapped that beautifully and really set up the history and what brought us to this point in the first place.
Yeah, no, that's a great point. It's one of those things where I can see in this instance why opponents of religious liberty would want to go there, but it's one of those things where it's like, do you really want this precedent, right? Because if all a charter school contract is, well, you get money from the government, and then with it there are strings attached. So you're essentially in this contractual agreement where you're doing some policy initiative that the government wants and taking money in exchange for it. Now you're a state actor. Like, with all of the grant money, all of the, the funds that come from the federal government with strings attached, isn't there an analogy that, like, all of a sudden a whole lot of nonprofit organizations become quasi state actors if you set this precedent? I mean, do we want to go there? Anyway, we'll leave that question hanging. Maybe that's an overreach, but I do think it opens the door to a lot of problematic analogizing. Um, so now we move into the First Amendment issues. The second question that the court addresses here: does the government funding of a religious school, in this case, violate the Establishment Clause? I really don't have a whole lot to say here that wouldn't be repetitive of what I've been saying on this issue every time it comes up. But I think it's just worth noting that the attorneys for St. Isidore, I think they summarized the proper answer in like a few words here. They said, establishment is to establish one sect or one religion to the exclusion of others, period, end quote, full stop. That's not what's going on here. And again, it would only be what was going on here if they approved St. Isidore's and then denied every other religious school from this charter school program categorically because they were non-Catholic or something like that. So I think that's kind of the end of the analysis if you properly read the Establishment Clause. I don't know. Is it deeper than that, Mary Margaret? Is there anything you want to add on the Establishment Clause side?
Yeah, I think that you're exactly right. In a way, it overlaps with the state actor question. Anytime the government collaborates productively with a party, that party is not a state actor, and the government is not establishing whatever that person is doing. They're collaborating on a particular project for a particular reason. And so I think that that analysis holds true here. And I also think, and yeah, maybe I'll refer to this a bit more in the end, but looking back at like the Shirtlift case, which was the flag case in Boston, the Coach Kennedy case, Carson v. Makin, this is not a radical ask from St. Isidore. It's the logical conclusion of several 9-0 decisions. This is not radical, or even, I think, yeah, it's not a stretch to say that a program that, yeah, I don't think it's a stretch to say that the government can collaborate productively without establishing a religion in this case.
Yeah, I agree with you completely. I think once you read Carson v. Makin and you take the Supreme Court's precedent for what it is, obviously there's a difference in that the funding of the religious schools in Carson was more indirect, right? Because you're giving vouchers, if I remember the structure correctly, to parents who can't reach public schools, and the parents can spend the vouchers at religious schools. But the framework is all there, right? If you're because the rule in Carson v. Makin is no, you can't exclude them from spending at these religious schools just because they're religious. That's not an establishment of religion. It's a violation of the free exercise clause to exclude religion that way. To me, whether the funding is indirect through a voucher or direct from the government through a charter contract, the logic applies. It's the same thing. I I'll hedge a little bit at the end because of the makeup of the court again, but I mean, I think if you faithfully follow Carson, this is the only place you can end up that Saint Isidore is correct on this. But we will find out in a few more weeks. So, briefly, we kind of covered the free exercise clause, and so I'll just kind of recap what we've said here. So again, the school's argument here is that excluding them from the widely available funding, again, echoes of Carson, solely because of their religious identity is a blatant violation of the free exercise clause, and it essentially penalizes them for their faith. And I think that's right, because the charter program is not, it's not a narrowly tailored thing. It's not like a trade school program, right? Where you're saying, no, this is to teach kids how to be plumbers and electricians and carpenters. Religious schools don't belong here. It's a different category of school. That would be a different argument. This is generally available, right? Like the nature of charter schools is very broad. You have like VOTEC kind of schools, you have classical kind of schools, you have, maybe like more Montessori leaning ones. You have all different types of education and teaching methods and ideologies and things being taught at these. So to create a system that says, yep, this is general funding, it's for all kinds of schools that want to apply and become charter schools, oh, but not religious identities, like that's excluded. I think that's right. I think, again, not to repeat myself too much, but this is Carson v. Makin all over again. You're opening this up to all kinds of schools except religious identities need not apply. I think if you read the Supreme Court's jurisprudence on the free exercise clause for the last 10 years or so now, this is where you end up. I think that St. Isidore is correct. I think there's a really strong case to be made. And I think if the court is going to follow precedent, then we get a victory on this. Anything you'd like to throw in there?
I think just to close, I would love to recap how we got here. I was listening to the oral arguments on Tuesday and just it was very energizing to see the dots connected. So I actually just wrote down a timeline of like the cases that set the stage for this. We had the 2017 Trinity Lutheran decision where the government said you can't single religious organizations out for disfavored treatment in a program that's open to everyone. And then in 2022, we had the Shirtlift case, which said that if the government opens a forum for private speech, they can't include everyone except religious speech. So if you can fly the, LGBT flag or the Irish flag, you can fly the Christian flag on the Boston flagpole. And then we had that same year Coach Kennedy, and that was more of the focus on the state actor, where the opponents of religious freedom were saying, well, the coach was a state actor when he knelt down on the football field after the game. And so he had no First Amendment protections. And the Friends of Religious Freedom were, of course, saying this was a personal moment after the game, as if you were, texting a family member, good news, we won. And therefore, the First Amendment is fully active. And then that same year, also Carson, where generally available benefits can't be conditioned on the renunciation of religious beliefs, and that sort of but for test, like but for your faith, you'd be eligible for this program. We've, pretty conclusively established that violates the free exercise clause. So I think just this is really, I think St. Isidore is really bringing all this together. Like the government discrimination on the basis of religion is highly suspect. The denial of benefits because of religious identity is suspect. Uh, and then discrimination against viewpoint. And I think actually Shirtlift didn't come up in oral argument, but I really thought that that was a relevant case because in Shirtlift, it was like all different voices could be heard. And I feel like that's the case with the charter school. It's been open to, I think, uh, shout out to Jim Campbell, who masterfully argued this case. He mentioned there were Native American charter schools, environmentally focused charter schools, and like all kinds of viewpoints were represented except for this one. And so, and then I think finally we just have the clarity that from Carson versus Makin that um, strict scrutiny is going to apply in this kind of dynamic where a religious organization, because it is religious, is being excluded from a program. So, the justices obviously had a lot of questions. There were a couple. The one hypo I thought was interesting, and I cannot recall which justice actually said it because I was listening and I don't know them all by voice. But it was the question was if the government wanted to paint a mural on the side of its building, would they have to have a religious mural if they did like an RFP, basically, request for proposals? And I think that was an interesting hypo because it's so clearly short-lived. It's like, well, if you're gonna have all viewpoints represented, then yes, and if you're not gonna have all viewpoints represented and it's not a forum for private speech, then no. I was sort of surprised that that was being relitigated, and it seemed a little irrelevant, but I don't wanna sound critical of that. But anyway, it's interesting, and I think to your point, Frank, where we actually land versus where we could and should and I think precedent would lead us to land is an open question, but there's no doubt that this is a really interesting opportunity to connect the dots with the religious liberty victories of the last 5 years in particular.
Yeah. No, I agree. Those are great insights. I like the free speech, viewpoint based discrimination side too, which you're right. Like it does, because of the way the questions presented were set up. This is a pretty straight, right, free exercise establishment clause question. But I think that the viewpoint discrimination argument is really valid and worth discussing, even if it wasn't central to the legal arguments. One thing that I will note here, just like I said, to hedge a little bit, and also because everyone in the religious liberty movement has been so excited about this for so long, right? I think I was saying to you, Mary Margaret, I think I wrote my first piece on St. Isidore before there was even litigation filed because I had heard about the organization of it. And the day that the cert petition was granted, I was getting text messages from friends about how St. Isidore was going up to the Supreme Court. So obviously, we're all deeply invested in this. So I think it's worth kind of just realizing some of the realities on the ground. The reality is Justice Barrett recusing herself for personal reasons from this, it does change the nature. I don't think it will change the outcome if I had to guess, though I don't like to guess, but it does make a difference, right? Because at this point, you need 5 of 8, and three. Again, we don't want to predict too much, but I think 3 of the justices are a little skeptical of funding using government funds for a religious school. You can guess which 3 I mean. But then what that leaves is you need all 5 of the justices who are generally considered conservative or conservative leaning, right? So, which means practically here you need, yes, Justice Kavanaugh, but you also need Chief Justice Roberts to sign on to get a majority. So again, I don't want to predict what a narrower opinion would look like, but it is kind of the Chief Justice's MO that he likes to avoid like sweeping changes um, in overruling precedent. And generally, he likes to narrow opinions to make them like less controversial. He's talked, I think, pretty openly about maintaining, the credibility of the court in his view. So I would just say that I would keep that on everyone's radar. That like while we would like bold, sweeping precedents to come from this case, and maybe we will get them because, like we've said, the precedent from Trinity Lutheran to Carson v. Makin, I think, is so clear that maybe the chief will say like, no, this is just the obvious next step in where we should be headed. Don't know. But I do think it is at least plausible that we would get a narrower ruling that would incrementally keep building on the line of cases that we've been discussing, since the court does need the Chiefs' vote to get to 5 on this case. So that's a little bit of like inside baseball from the court. I don't know if you feel differently or if you have any thoughts on that. We hate to have to think like that, but that's the reality. Every justice and their persuasions matters.
Yes, Frank, I think you're 100% right. We are probably going to get a very narrow ruling here, but I'll take it.
Yeah,
Uh,
we're
yeah,
before we move on to Indiana, just letting everyone know if it's not obvious, we will certainly be watching this case closely. So I assume that within a week of this ruling coming down, you will hear us
that's right. Yes. And on the topic of education, we have an
talking
important
about St.
bill.
Isidore.
We have an important bill from Indiana to talk about today, and I think this bill, which was recently passed, matters for 3 reasons. So this is a parental rights bill. It matters a lot if you've been following this podcast. You saw the Mahmoud versus Taylor case. In that case, went all the way up to the Supreme Court. Just a group of parents trying to have their children exempted from some objectionable sex education materials. So if a law like the one that was recently passed in Indiana had been in effect in Maryland, I think we would have seen a lot more clarity in the Mahmoud case, and we would have gotten answers much sooner without having to run all the way to the highest court in the land to get our questions answered. The second reason that I think it matters is we've been seeing and hearing about some very heartbreaking situations where parents are trying to help their children, adolescents in particular, navigate difficult questions about sexuality and gender identity. And as these parents are trying to navigate their children in the way the parents believe is in that child's best interest, schools are intervening and actually locking parents out of the process. So these schools are affirmatively adopting policies that exclude parents from conversations with the school counselor about gender identity. And they even have children kind of um, claiming or attempting to transition under the guidance of not their parents, but school officials. So this is a very live issue, and Indiana's bill protects the rights of parents and establishes a strict scrutiny burden in 3 circumstances. Uh, so basically, the text says, and the government cannot burden the right of a parent in these 4 areas unless there's a compelling state interest and there's no other way to pursue that interest. And the 4 areas are the upbringing of the children, the religious instruction of the children, the education of the children, and the health care of the children. And the government may not deny parental access to information on any of these areas um, without satisfying that same strict scrutiny burden. And there's actually a private right of action, so parents can sue the government for relief. So this would be, if a school counselor leads a child to make a certain decision about that child's health care and intentionally hides this from the parent can sue the government for relief for that action. Um, so this is a really important bill, a really big victory for parental rights. And I just want to close by noting you might be wondering how we got here. Isn't there something in the US Constitution about this? And I thought it would be worth mentioning. Um, so the US Constitution Bill of Rights does not expressly protect parental rights. And the courts over the years, in cases like Pierce versus Society of the Sisters of Jesus, have found an implied parental right or parental rights as a fundamental right, but it's not in the Bill of Rights. And that's not because the founders forgot about it, and that's not because we don't have rigorous protections for that. It's simply because the Bill of Rights was not meant to be exhaustive. So while we have some people go to the other extreme and start saying that the Bill of Rights is supposed to protect everything from internet access to, I don't know, um, crazy things. Um, there are also fundamental rights that were not listed in there and that people have very valid claims to. And parental rights, of course, falls in that area. But because the Constitution hasn't expressly provided it, there can be some ambiguity about exactly how those rights are protected and avenged, for lack of a better word. So, for that reason, I think state legislation like this bill in Indiana is critical because we'll have clarity and we'll have a clear way to avenge these rights if the states act to protect parents in this way. And finally, it really falls to the states even more than the federal government to protect this because the federal government only has enumerated powers. And so they aren't supposed to be in the business of running people's families. Um, it's actually the states that have the general police power, and so day-to-day life, family structure, social things like that fall much more into the realm of, individual states, and of course, we'll take the position that a lot of times even that's none of the state's business, but to the extent that it is the state's business, they have the ability to bring clarity and I think justice to this area. So, Frank, I would love to hear your thoughts on this. We've talked parental rights indirectly, but I think this is the first time we've had the opportunity to really hit this head on. So I would love to hear your perspective on this bill.
Yeah, I mean, first of all, it's a great bill. I think these are needed statutes, but I want to talk just for a minute. You hit on something that it just came to mind that I want to touch on is that the historical reality of the Constitution and the Bill of Rights matters here as well. Because if you look at the Bill of Rights, like you said, it's enumerating certain rights. It's not meant to be exhaustive. It's pretty obvious from when you read the Ninth and Tenth Amendments that there were other rights that were not being protected by name here in the Bill of Rights. But if you look historically at why did they choose the rights they did, right? Why not include parental rights against the government in a Bill of Rights or in state constitutions at the time of the founding? And I think there's a fairly obvious historical answer to that. The rights that were protected explicitly are rights that were endangered by foreseeable circumstances, right? Like, why have an enumerated right to free speech? Because they had seen plenty of instances of governments trying to shut down opposing viewpoints to maintain political control, right? Why have a right to bear arms? Well, because it was fairly obvious that if you want to be a tyrannical government and shut down the ability of the people to be independent and so on and to protect themselves, you take away their guns, right? Why have the Third Amendment against quartering soldiers? Because the English would quarter soldiers in people's houses, right? So direct response to actual real or perceived problems in their society, right? So I think that's relevant because parental rights is just we live in such a fundamentally different society with fundamentally different institutions today that I don't think that would be really on the radar because there weren't really public schools, right? There were not these elaborate systems of schools that could like teach your kids things against the parents' will. Like to the extent people went to formal schools, it was like totally voluntary, right? You could go to schools, not go to schools. There was no like overarching public school system that would demand that your kids would ever learn anything, right? Let alone the kinds of controversial things that are being taught in schools today. And then like, child protective services, CYS, all these mandated reporters that could come in and say that you're doing something that was not in your child's best interest. Like these largely didn't exist. So not to put too fine of a point on it, but I think it's worth bringing that up that, all the more reason that we should have state statutes and legal movements to address these because yeah, it's not in the Bill of Rights. It's not a traditional thing that was explicitly enacted by law to say parents have rights over the government because at the time of the founding there really weren't all that many situations where the government was all that interested in asserting any rights or anything like that over children at all, right? So you have to pass new laws to adapt to new circumstances and the circumstances certainly warrant laws. I think like what Indiana has just passed here. So I guess with that, we will turn to our final issue and won't spend a lot of time on it. This is one of these kind of honorable mentions, not a ton of legal complexity that we want to go into. We just want to make sure that we bring it up because I think it's a long saga that's finally over, and I think it's worth the attention of our listeners. So we're going to move here to the University of Louisville for something that's been going on for I think it's been 8 years now. So This is censorship in academia. It's been a hot button issue. It's garnered a bunch of scrutiny and media attention, especially in the last few years. So here, it was a professor named Dr. Alan Josephson who got into a pretty severe conflict that ended up with the loss of his professorship at the University of Louisville after he criticized the rapid and widespread prescription of puberty blockers to minors while engaging, by the way, in a private speaking event. This was not something that he was even teaching at the University of Louisville, although even if he was, I would say that would still be fine. But um, this was a panel that Dr. Josephson presented on in 2017 at the Heritage Foundation, where he advocated for psychological treatment rather than biological intervention for children who are experiencing gender dysphoria. So soon after this panel participation, Dr. Josephson was demoted from his senior faculty position at the university to junior faculty member. That was in 2018, I believe. And then about a year later, in 2019, the university decided not to renew his contract and he lost his job. So 2019, 6 years ago now, he filed a lawsuit. I believe he was represented by Alliance Defending Freedom. Is that right? Yeah. And he filed a lawsuit against the University of Louisville for his illegal treatment, reached a favorable settlement just recently, 6 years after litigation ensued. He was awarded $1.6 million in a mix of damages and attorney's fees. So, first of all, great outcome after a lot of years of suffering. So, I'll get to the various reasons we should applaud and be grateful for this decision. But I think we've made this distinction several times in different contexts on this podcast. It's important to note this is a public university, right? So even with private universities, you'll often get federal funding, and therefore you're subject to certain federal guidelines, strings attached to the money. But this is a public university, so you have a state actor, a real state actor, right, involved here. So there are First Amendment free speech protections at play, right? That doesn't mean there can be no standards of conduct for professors in their outside work, right? You can't just say or do anything. There are certain things that would be probably ethical or moral conduct violations that would be legitimate grounds for termination. But this seems to be a pretty classic case of viewpoint discrimination, right? Um, the it's primarily a free speech issue, but it does set an important precedent that's relevant to religious individuals, right? Because things like this, the defense of the realities of human nature, of biological sex, and so on, are often held and defended in the public square most strongly by religious individuals, right? So when you have a public state actor, a university in this case, that can say, no, if you speak out and express the truths of human nature, biological sex, and so on, in a way that, in our case, is reflective of um, Christian belief, but even if not, just even if it's just based on your academic understanding of biological reality, if you can be fired for that, it's a huge chilling of speech, right? Who's going to want to speak out when it's like, well, if you take the wrong side of these issues in the public square, especially as an academic, where this kind of robust debate should be at its highest and most protected, huge chilling effect, right? So important to have these wins to tell these state actors, no, you can't just you can't just do whatever you want. You can't just remove viewpoints that you find unpopular. It sends a really strong message, I think, that this is not okay. So, sorry, I know I lost you for a minute there, Mary Margaret. Are you back in?
Back in, yes, thank you.
Yep, sorry about that. So just a couple of things. I was just kind of covering, the importance of this precedent for religious people because we're the ones who tend to be fighting these battles in the public square, and it would be a really chilling thing if we're not allowed to speak, or else we could lose our roles, especially roles from employers that are also state actors, right? So then I guess there's the question of, does this set a legal precedent? It depends, not really, right? This is a settlement at the trial court level. It did go up to the Sixth Circuit. The Sixth Circuit did rule that this was a retaliatory action that required a trial, and it was sent back down to the trial court. But ultimately, this is a settlement. There's not a whole lot of legal precedent, but it does send the public media, right? It sends a message. So I think it's precedential in a certain sense, right? And it's heartening to see a message sent that you can make a conservative religious statement in the public square, and it can't be targeted and silenced by a public university or another public institution that happens to be your employer. So I would just say, before turning it over to you, we're grateful to Dr. Josephson for fighting for years, right? Putting his livelihood at risk, his reputation on the line, for saying something that, as more and more science comes out, is starting to become consensus too, right? This isn't somebody standing up and arguing for like Nazism or like the supremacy of a certain race or something like that. This was a very tame thing that he said, that, gender dysphoria, it's a psychological issue, and treating it psychologically rather than jumping right to, you know, chemical interventions and surgical interventions on minors is a prudent thing to do. Like, this was not should not be a hot take in a sane society. So maybe I'll leave it there and turn it over to you, Mary Margaret.
I agree. I really like, Frank, how you emphasize how the First Amendment freedoms really do travel hand in hand. And so, as much as that, in a sense, the religious freedom jurisprudence, especially free exercise, develops autonomously, at the same time, cases like this show you, the free speech, academic freedom, and religious freedom, they're certainly traveling in the same train. And here, just like we saw with Coach Kennedy, we had an individual engaging in private speech and then a public government actor uh, attempting to intervene to suppress that. And I guess the second bottom line to me is just how much Professor Josephson has been avenged. Like you said, I mean, we had the Trump administration saying in the executive orders this year that there are certain truths about the human person that are just that, they're true. And then the scientific community really um, speaking more clearly and openly about that intervention is not always the right treatment. And in fact, I think a lot of scientists are saying that it's never the right treatment. That treatment outcomes are not favorable. And I remember when this case came out with Dr. Josephson, it just seemed like there was. It just seemed so dark. Like, things seemed so oppressive. It seemed like these universities were going to do this to everyone, and that anyone who didn't kowtow to XYZ pronoun policy or whatever, that everyone was just that this was going to be the end of it, and we were all going to have to go underground. And that's not how it played out. But I have to praise his courage, because he took this position, as the kids say, before it was cool. And I'm not sure it's cool now, but it's definitely, hopefully, not something a lot of people are losing their job for now, or at least fewer people are losing their job for. And so, I think my biggest takeaway from the case is just the moral courage, and that ultimately, it became clear that even though he was maybe just a single leaf on a very big tree at the time, an entire movement has really rallied around that, and he certainly doesn't stand alone now. So, praise to Professor Josephson, and praise to ADF for protecting his voice at a time when no one else really was.
Yeah, you made a brilliant point there. So I just want to end with one thought that I think is important, because I think the religious liberty movement, and maybe in a lot of ways, a lot of factions, or not factions, but movements within the general right of center world for a long time have been on such defense that we've kind of almost focused on this like values neutral defense of what we're trying to do, right? And I think we may be at a little bit of a turning point where we can stop only arguing that way, right? We have a mutual friend whose name I won't mention because she's now no longer a nonprofit worker, but a member of the administration, but who said recently that, at a certain point on these issues, we're going to have to stop just arguing that, well, we have the, public square, we have the right to say whatever because I have the right to say it. And we're going to have to start arguing that, no, we should say these things because they're true, not just because we have the right to say them, but because it's important that the truth be spoken in the public square. And I think there's kind of a turning point now where it's not just like we want the neutral right to be free to exercise religion or speech. Those are important, right, for a wide swath of people with a wide variety of beliefs. But at the end of the day, we need to defend the right to say things that are true. And so again, hats off to Dr. Josephson for really sticking his neck out there and suffering for years, for the truth and his right to speak the truth.
Great. Well, thank you for joining us for another episode of the Napa Legal Weekly Podcast. If you enjoy our content, we invite you to like, subscribe, follow, whatever the kids do these days. And of course, you can find us at napalegalinstitute.org. We hope you'll join us again next week for another episode of the Napa Legal Weekly Podcast.
Talk to you next week. Thank you as always for joining us, and God bless you.